Under Section 351 of the Internal Revenue Code, no gain or loss is recognized if property is transferred to a corporation in exchange for stock in that corporation. In James v. Commissioner, we consider whether the term property includes services rendered to the corporation. William James, a builder and real estate developer, entered into an agreement with Mr. and Mrs. Talbot to construct an apartment building meeting Federal Housing Administration, or FHA, standards. The Talbots agreed to contribute land, while James agreed to secure the necessary financing and FHA commitment and oversee the project's construction. Additionally, the parties agreed to form a corporation to take title to the project, with James and the Talbots each owning 50% of the corporation's stock. James successfully obtained a mortgage commitment from United Mortgagee Service Corporation and a commitment from the FHA to ensure such financing. However, the FHA required that the mortgage be issued to a corporation. Accordingly, James and the Talbots formed Chicora Apartments Incorporated. The Talbots transferred their appreciated land to Chicora in exchange for half of Chicora's shares, while the remaining shares were issued to James. On their income tax returns, neither James nor the Talbots reported any income related to their receipt of Chicora stock. They reasoned that the exchanges were tax-free under Section 351 of the Tax Code. The Commissioner of Internal Revenue disagreed, arguing that the stock received by James was issued for services, not in exchange for property, and was therefore taxable as ordinary income. Furthermore, because James received his stock in exchange for services, the Talbots didn't meet Section 351's control requirement, and they were, therefore, also taxable on the gains they realized from their transfer of appreciated property. James and the Talbots petitioned the United States Tax Court for a redetermination,